this is a summary of what I'll be touching on today. As you can see, we're sort of pretty much doing fire, flood, disease, death, the whole works. At the very end of my regulatory update, I will talk about how to handle an investigation, and I will respond to one of the questions that I was answering in the breakout room before we were pulled back in. So whoever the lady that was asking me the question sort of got me sort of halfway through, and then I hadn't quite finished. So I will bring that up later. So if I could have the next slide, please, and we will talk about the fire safety bill, which passed this year on the 29th of April. Although not all sections have been brought into force yet, but the Act is there. Obviously, this is part of the follow-up to the Grenfell Tower tragedy. The press, when reporting on this bill, have talked about the government's failure to pass on the costs of remedial work, or to prevent those being passed on to tenants and impoverished homeowners. But today I want to focus on how the changes in the Fire Safety Act could have practical consequences for your companies. Basically, the Act amends the Regulatory Reform Fire Safety Order of 2005, that we all know as the Fire Safety Order, and that's the law that imposes the duty on the responsible person, which is an employer in the workplace or an occupier of non-domestic premises, or at the end of the day, the owner of such premises, to manage the risk from fire. Now, the Fire Safety Order already covers most premises in England and Wales. There are certain limited exceptions, and one of those is private dwellings. So that means that the Fire Safety Order applies to the communal areas of residential buildings, but not the domestic premises within those buildings. And that led to a degree of confusion in those buildings as to whether certain structural elements in a block of flats, for example, were to be treated as part of the communal areas and therefore covered by the Fire Safety Order, or as part of the private dwellings and therefore excluded. So that's been resolved, and now the Fire Safety Order, by virtue of the Fire Safety Act, clearly applies to the building structure, external walls, doors between domestic premises, and doors and windows and anything attached to the exterior of buildings. So obviously, if you're a person responsible for managing fire risk, you start off with a fire risk assessment. Now that fire risk assessment covers the building structure, external doors, etc. Although the Act that has not brought in that particular section just yet, I wouldn't hang around if you're responsible for a building in trying to get your fire risk assessment regenerated, because there's some very real practical problems by this extension. The National Fire Chiefs Council reckon that about 1.7 million residential properties will now be covered by the Fire Service Order and the changes that are made by the Fire Service Act. And remember, it's not just high-rise blocks of flats as been reported. It's any building with 2 or more domestic premises in it. Now, that's going to increase the workload for fire risk assessors. They're going to have to look at the external of the building and so forth. Of course, that's going to drive up the costs of their assessment. And frankly, there aren't enough fire risk assessors who are qualified to assess both the internal and external aspects of a building. Cladding engineering and facade surveying is a specialism in itself. There's another little tricky point, which is that the fire risk assessment should now have a sort of a tick box if the assessor thinks that there might be something wrong with the external walls, and therefore they make a priority recommendation that those walls are assessed. Now, if there aren't so many people who are qualified to make that assessment, they're just going to cover their backs by just ticking the box and saying, yes, it's a priority recommendation, which sort of puts the problem back in your court. So my tip is to make sure that your fire risk assessor actually can do the new type of fire risk assessment. And then to make sure that they are going to cover all the bits that are covered in the Fire Service Order. So it won't just be looking at cladding, it's going to be looking at lifts and evacuation procedures and defective fire stopping as cladding is removed, and so on and so forth. So that's a sort of practical aspect of the Fire Safety Bill, the Fire Safety Act, that you just need to be aware of it, because if you're working for an employer, they are responsible for the buildings. So having done fire, let's move on to flood. If I could have the next slide, please, with the Environment Bill. Although the Fire Safety Act walks hand in hand with the Building Safety Bill, I'm afraid when I was preparing these slides, for some reason, the filing clerk in me thought, oh, I'll deal with 2 acts first and then go to a bill. So it does sort of break it up a little bit. So I apologise for that. But the Environment Act is now, had received royal assent just at the beginning of this month on the 9th of November. The bill itself was introduced in 2019. At that time, DEFRA claimed that, and I'm going to read this out because it's such a cracking quote, it would do no less than clean up the country's air, restore natural habitats, increase diversity, biodiversity, reduce waste, crack down on water companies, introduce world-leading species targets, and deliver the most ambitious environmental programme of any country on earth. Well, it is certainly a monster of an act. There are 149 sections and 21 schedules. It takes forever to read. It is divided into parts which pretty much cover that DEFRA announcement. So, you go from waste to air quality and so on and so forth throughout the Act. But it does mean that it's touching on an awful lot of aspects of modern life. So from plastic shopping bags to car disposal to sewage to biodiversity, there's something for everybody. So my key message today is to double check the Act and make sure that if there's any element of it that applies to your company's business, particularly if you're in a sector with a large environmental footprint like construction or energy and so on. Now, whilst most of the Act is not yet enforced and will come into force next year, it's better to be prepared. There's been a lot of media coverage of the new Office for Environmental Protection, but that's the kind of government body that's regulating other government bodies. You'll still be having to keep a weather eye on the existing regulators, such as the Environmental Agency and the local authorities. I say that particularly in light of the fine imposed on Southern Water earlier this year. That was the largest criminal investigation in the Environmental Agency's history. Pollution offences from 16 wastewater treatment works and 1 storm overflow coursed together, if you'll forgive the pun, into 1 prosecution dealt with at Canterbury Crown Court. Now, even after getting credit for entering a guilty plea, Southern Water was fined £90 million. So on the subject of sewers, the Environment Agency has also been busy with combined sewer overflows. They're the sort of old-fashioned Victorian pipes that unfortunately meant that clean rainwater and domestic sewage are running down the same sewerage network. The Environmental Agency has identified 700 combined sewer overflows to investigate and 40 to be improved in the next 5 years. So they're out looking for work, and they've got plenty of work to find, and obviously that means plenty of investigations, plenty of fees, plenty of work for companies who are the subject of investigation. Last year, the Environment Agency established the Joint Unit for Waste Crime. That's a partnership with the police and the HMRC. They've been tackling waste and metal crime. They visit sites, stop vehicles, arrest offenders, and of course, end up prosecuting. And of course, remember that the local authorities can and regularly do prosecute offences under the Environmental Protection Act. And now, whilst those cases don't generate publicity like a major pollution incident like the Southern Water case, they are costly in terms of fees and fines and, frankly, time spent dealing with EHO officers who are convinced they know more about the law than all the judges on the Supreme Court bench. So talking of regulators, we'll get new ones, and existing regulators will be given even more powers in the Building Safety Bill. So if I could have the next slide, please. Now, the Building Safety Bill is that other element of the measures introduced designed to ensure that the Grenfell can never be repeated. The idea is to create a golden thread of information which is created, stored and updated throughout a building's life cycle, which establishes clear obligations on owners, and enable swift action to be taken by the regulator whenever necessary. So it is making the fabric of a building the subject of regulation now. It creates a duty holder regime, a bit like the duty holders in the construction design management regulations, if particularly those in the construction industry will be familiar with those. But it also creates some particular duty holders for high risk buildings. So that's an accountable person, a building safety manager. There will be things like a lock box for key documents. So it does get quite intricate and detailed. And residents themselves will be required to support the management of building safety risks. As I said, they've created a new building safety regulator, which actually be part of the HSE because it kind of fits in with their type of work, and they've got the expertise to just expand out into building safety, already touching on construction as they do. They will be covering all buildings with a view to securing the safety of people in or about the buildings in relation to risks arising from the buildings. So they're not just talking about work anymore, it's about structural things. And as I keep emphasizing, it is all buildings. There are additional provision for higher risk buildings, and they're defined as buildings of 18 meters or 7 stories, but they must have 2 residential units in them. So that's the high-rise blocks, but the ones with residential units in is the key sort of signifier to turn it into a higher risk building under this act. A bill. So it strengthens the regulatory framework for construction products as well. So another regulator gets yet more powers. So that's the Office for Product Safety Standards. They will have the chance to remove products from the market that present safety risks. The bill also extends the rights for compensation for substandard workmanship. So that's the Defective Premises Act, and it's going to be extended from 6 to 15 years, and that's going to have retrospective effect. So earlier I beg your pardon, I touched on the lack of cost protection for homeowners in the Fire Safety Act and how that's been criticised. Well, obviously this bill tries to bring that in now. Developers are required to join a new homes ombudsman scheme. That's a second regulator that's being created. And if they don't join it, they get fined for not joining it. They'll also face increased fines and up to 2 years in prison for non-compliance with building regulations. The bill empowers the Architects Registration Board to monitor architect competency as much as it currently monitors architects' sort of ethical behaviour. So there'll be more powers to the Architects Registration Board. This is not going to go through until April next year, and there's going to have to be a lot of funding handed over to the HSE for them to be able to run the building regulator properly. But beware, I mean, like the HSE can currently make you pay to be investigated under the Fee for Intervention scheme, that's going to happen with this building regulator, and so that's the way the government's going to recoup its outlay. So moving away from buildings, but staying with the HSE, please may I have the next slide. This is COVID and the HSE. Now, we all know that the HSE is concerned with health and safety at work, so as we're all lawyers, I want to just raise a technical legal point, which is that there is a serious legal question about whether COVID is to properly be regulated as part of a workplace risk within the scope of the Health and Safety at Work Act 1974 and its associated regulations, or whether it's an everyday risk for which the employers and self-employed are just not responsible. Now, that point, it might be technical until you think about the personal liability of directors and senior managers if a company gets it wrong, and it's down to the manager's consent, connivance, or neglect, then suddenly you as an individual are faced with being prosecuted because of COVID, just the existence of COVID. Now, there's an evidential point about, how can you prove the material increase in risk from COVID when the absolute risk of catching COVID is small? But these are just technical legal points that will one day be litigated, I'm sure. But the moment the HSE has adopted, frankly, a fairly light touch. All they've done is really follow up the Public Health England's recommendations on social distancing in particular. They are coming under pressure to take action where you have, say, clusters of cases. But frankly, I've only heard of one improvement notice issued to a construction company and one deferred prohibition notice issued to a retailer in all this time. So they are doing a fairly light touch. Now, I'll come on to talk about how to deal with an investigation, but I always recommend careful engagement with HSE inspectors in an attempt to avoid enforcement, but I would particularly mention that in relation to COVID inspections, because very often they're carried out by freelance inspectors, and they are not as well versed in the hierarchy of enforcement as standard HSE inspectors. So we've been talking about COVID and the HSE, and you're thinking about whether the Health and Safety at Work Act forces you to have your employees vaccinated. If I could have the next slide, please. Now, Michael's already touched on this slightly, so I won't repeat what he said. But obviously, we all are aware that mandatory vaccination has been introduced for care home workers and in some circumstances for care provided outside care homes. If your boss, your MD, thinks it would be a good idea to insist on vaccination for all the staff at your company, and they come to you as the in-house lawyer, what do you say in response? Well, Michael's touched upon the employment law aspects, but my first point is always that vaccination without an individual's informed and voluntary consent is an assault. It's assault and battery under the common law, and that's bottom line is you can't do it. The Health and Safety at Work Act doesn't require you to do it, as I've said earlier. There's a proper legal question about the risk itself. And nowhere does it force you to do it. So you can reassure the MD that doesn't have to happen. The biggest thing, sort of practically speaking, is the data protection elements of the COVID vaccinations and inquiring about vaccination status. You can ask your employees if they've been vaccinated, but you're going to have a good reason to know that. And then you've got to think about how you protect that sensitive personal health data under the GDPR and Data Protection Act. You've got to make sure that your data protection policy and risk assessment is properly protecting that information and that you've thought about it. Otherwise, you'll get into trouble that way. Though there's been talk about how requiring vaccinations could be somehow discriminatory, and much of the press has commented on religious discrimination, but actually it's more likely to be disability discrimination that's a point that comes into it. So there's a lot of laws to think about, and frankly it's a lot of hot water that you could get into. So what are the other steps that you could take that would achieve the same end? We can all get free lateral flow tests now. You can redeploy to a non-public facing role. You can offer vaccination as a benefit. There's a lot of things you can do without having to go down to the line of, do we really need to think about making our staff get the vaccine? So we've done fire, flood, disease. Let's move on to death. If I could have the next slide, please. One of the most distressing cases I've come across in many years of defending health and safety cases, thankfully not mine. I wouldn't have touched this one with a barge pole. Mrs. Frances Morris was 93. She had advanced dementia. She was losing the ability to communicate. She lived at Birdsgrove Care Home, which was operated by Birdsgrove Care Home Limited. She was bathed by two carers who failed to check the hot water temperature and continued to add scalding water. Mrs. Norris ended up with burns across 12% of her body and died in hospital 3 days later. The criminal investigation revealed systemic failings at the care home. It wasn't just the care workers pouring in the hot water. It turned out that the thermostatic valves hadn't been properly risk assessed. When they had, whatever points had come up in a previous investigation hadn't been followed up. There was some inadequate work on them. They weren't following, basic guidance. There wasn't enough maintenance going on in the care home generally, particularly with regard to hot taps. So it was a generally bad situation that came to light through the generally bad behaviour of two carers. The company that actually pleaded guilty in the end was actually the parent company of the group. And that's the legal point that I want to make today, is that that's fairly unusual. It just shows you can pierce the corporate veil. I don't know whether they offered themselves up to be fined or whether they had their toes held to the fire to do it. Given that they provided false information during the course of the investigation and that drove up the fine that they faced, I suspect it was the latter. So anyway, they were fined over £1 million and had to pay nearly £200,000 in legal costs for the HSE. I beg your pardon, yes, it was for the HSE and the police. So they have had their wrists slapped, not surprisingly. The two carers were also convicted of health and safety offences and were given suspended prison sentences. One thing to note, because I'm going to come on to talk about investigations, is that it took 6 years for this case to reach sentence. So these things, when something goes wrong, it takes an awful long time for them to be resolved. So if you imagine something dreadful like that happened at your company, how would you deal with the aftermath? So if I could have the next slide, please. I've posed a few questions here, which I'll obviously let you read, but one I would add to that is how familiar are you with criminal law? If something awful happens, everyone's going to come running to the in-house lawyer, and what do you do? So without trying to turn you into criminal lawyers, if you just give you a few top tips very quickly in the time I've got left. In workplace accident investigations, there are two concentric circles of interest. First, the root cause of the accident, what actually happened, who left the machine guard down, who left the cable for somebody to trip over. And then the underlying causes. Was the guard left down because of an informal practice on the shop floor that has arisen over time because it kept sticking and nobody had bothered to fix it? A bit like the situation in that dreadful corporate manslaughter case, what actually happened and what were the reasons behind it? If there's been a fatality, usually the police start investigating first. If no one has died, then the HSE starts off with the investigation. There is an enforcement protocol between the two of them. It's important to achieve the right balance between cooperation and then not basically making life worse for yourself by basically singing like canaries. Very often people are far too keen to incriminate themselves unnecessarily. It's important to set up a good working relationship with the investigating officer, whether it's from the HSE or the police, but keep a detailed log of what you tell them, please. They can enter the premises at any reasonable time, or if it's a dangerous situation, at any time at all. They turn up and they may need to sail off the scene of crime. They're looking generally for information about your company, for documentation. They might need to remove articles, equipment involved in the accident. They'll be taking statements from key witnesses, and they're looking at also what's happened since the accident. They should always be accompanied. Don't speak in front of them. They're wolves in sheep's clothing. They can write everything down and it comes out in a prosecution later on. They can, the HSE can issue, and the police cannot issue, in prohibition and improvement notices. If you get one of those, don't ignore it. Don't just accept it. They can be appealed. It makes life worse for you. But they are kind of official notices that need to be handled under the Health and Safety at Work Act. So make sure you know what to do with those. They're allowed to take copies of all documents. They may ask for documents to be specifically volunteered. They keep a record of what you've handed over. And remember that they're also going to ask about post-incident documents. So make sure whatever you write down doesn't land the company in it. In terms of statements, you don't have to give a voluntary statement. If anybody is wondering about PACE interviews, then you're only asked for a PACE interview if the police or the HSE have reasonable grounds for believing that the interviewee has committed an offence. Whilst a corporate entity will be interviewed via its directors, if any of your staff are invited to a PACE interview, they need their own legal representation because it's them in the frame. In terms of your internal investigation, be frank and honest, but don't write opinion down. Don't blame anybody. Don't sort of say my opinion that is that so-and-so was responsible for all this. And just check your legal privilege. Finally, you'll need to notify your insurers. They obviously have an interest in the outcome of civil claims for compensation, but frankly, defence legal costs for criminal cases are just a burden for insurers. So they try and limit them wherever they can. They might try and pass you off onto panel firm solicitors, but even then, they keep it very limited. If they do try and pass you off onto panel firm, then you can always say that you're entitled to instruct anybody you like. That's enshrined in law, and so you can insist that you don't have to have their panel firm. But my main takeaway message is to just be very wary. If you've had something, even though they're smiling, they're looking for evidence on your company. Now, if I've run over, I'm sure Elizabeth will shoot me after this event. So I apologise, but thank you very much for listening.